Okay, everyone, welcome, welcome. It's November 13th, the last webinar of 2024 for the trust topic. And we have some illuminaries on with us today. Our dear friend uh, Randall Hillner is retiring. He's gotten up in years and his health is declining. And so we have a younger and more robust and equally excellent, in fact, better in some ways, with customer service, client service, Bradley Long with us today, who is doing the trust writing. Welcome, Bradley.
Hey
And
everyone, really happy to be here.
my old friend Will Barney, who is a hit with audiences everywhere,
Thank you.
who is not
Glad to
only
be with you.
a champion of world news, but also a supporter of the Natural Law Trust. So I'm sure there'll be temptations, gentlemen, for people to ask about topics all over the map today, but we'll try to keep it mostly related to the trust topic. And so, everyone, we will have Will Barney next week, Thursday, the 21st, for an all over the map kind of session, for topics ranging from this planet to whoever knows what dimensions, but basically the banking system, the politics, the hidden behind the scenes improvements and evolution in this world. Well, everyone, we have membership in the Worldwide Charter for International Commerce, Fair International Commerce. So that's important. And if you haven't seen it already, look at that page on the website because we believe in it and we live up to it. Today, November 13th, and our next trust webinar scheduled for January 15th, although we'll see what happens because anything could change. So watch the newsletters. Uh, let's keep moving, and I'll just say for those who need it, we have a phone number 360-200-7521 in the United States. And you had an opportunity to dial into this talk, this meeting, if you had wanted to do so by phone. I'm Tonson Fairmont. I'm the founder of Brilliance in Commerce. I've been a consultant in bank instruments programs, a speaker and author, and you can see the bio there. Randall Hillner has been the founder of our trust uh, that we've been using and writing for people, the creator of the House of Freedom International Natural Law Trust. And Randall is retiring, and his proteges, his advanced students, and those who are up to speed with how they're written and how they're managed are coming in and assisting now. So we wish you, Randall, wherever you are, I'm saying that because I don't think he's on the webinar today, but we send our love and our blessings and our gratitude for the legacy of this incredible crafted instrument, which really still to this day has not really been eclipsed by any other design. Laurel White is also on the team and is still assisting where needed. Whenever there's a need for some service that we, don't do directly between Bradley and myself, Laurel's there. She's a backup. Her contact information is given to every client, and she also writes PMAs, the non-statutory private membership associations. Bradley Long is passionate about helping people escape the matrix and reclaim their sovereignty. He's dedicated to humanitarian projects and helping awaken people protect their assets and families with private trusts. He has championed the unsurpassed qualities of BIC's Natural Law Trust. He supports the sovereign revolution with his expertise in non-statutory law, natural law, and freedom technology. Bradley lives with his wife and 6 children in Latin America and is trustee of a child-led school that teaches children sovereignty. And ladies and gentlemen, rather than present a teaching topic to you today, we thought we'd rather let you guide this meeting today and tell us in your questions what you would like to discuss. So feel free to raise your hand or to type into chat. And while we're waiting for the questions to come in, Will Barney, I want you to just say hi to everyone and give me a few sentence words of wisdom for the day.
Well, I appreciate the opportunity to be with everyone this evening. I always love talking about this topic because trusts are an incredible vehicle, and anyone that's seeking independence and privacy should be looking at these. It's been very helpful for me. I have one of these, and I can't think of anything better. And I've tried them all, corporations, LLCs, everything. But there's something unique about these instruments that I think are powerful, particularly as we're launching into an age of projects where we're moving forward to embrace the humanitarian work that needs to happen to rebuild the world from where it is currently. This is the perfect time for everyone to be learning about this vehicle that can help you structure your project and get it in a place that it's ready to serve the world in a manner which you desire. And I love how it provides the mechanisms of protection and liability isolation, if you will, to allow these things to happen. As you know, we live in a very litigious society where there's a lot of interesting things that occur. Uh, you know, there's a place for that, and if people have been harmed or damaged, it makes sense. But we want to always structure ourselves in a way that best protects what we're trying to do and accomplish. And I think that these trusts do that best. So it's been a pleasure for me to get to know you, Bradley. This is, I think, my first introduction, although I do know Randall and well, he's an incredible man. So we'll miss him.
Absolutely. Yeah, pleasure to meet you, Will.
Yes, it's wonderful getting to know you. I'm sure that questions are going to start coming in. But one of the things that I find most fascinating about using natural law trusts is that they work with us. They're designed to be flexible to adapt to each of our unique situations and circumstances because we're in a world where we interact with people. And so each individual's circumstances can be unique and can be different, but there's flexibility within this type of vehicle to tailor itself to those unique needs and to serve the needs of the beneficiary, I think, in a way that is best for them and for whatever legacy is being left with a trust. So I find that one of the most amazing parts of this is that whether somebody is looking to structure a company, a project, a ability to launch some endeavor where you're trying to conduct business, this offers all of those facilities, yet in a way that provides protection and privacy. And I don't think that can be understated in a world where both of those seem to be fleeting.
I like your phrase, Will, liability isolation. Yeah, that's a very good way of putting it. Well, we have a hand up, Glenn. Let's go ahead and unmute you and or ask you to unmute and say hi to us.
Hello, good afternoon. Appreciate y'all showing up.
Hi, Glenn. Yes, very good.
I've got a two-part question. One is, can a trustee, and pardon my ignorance, be a beneficiary?
Bradley, you want to address that?
Yeah, so hi, Glenn. Yes, you can. Absolutely. You just cannot be the sole beneficiary.
Okay.
All right.
Uh,
But in an ideal world, I would say it's if you can avoid being a beneficiary, it's better. It makes the trust more robust. But I would say as long as you're a minority trustee, beneficiary, sorry, it's absolutely fine. The reason I say it's better if you can choose not to be is because if you're transferring any property into the trust, if that transaction ever came under question and it was deemed that you were trying to avoid some sort of taxation, it would weaken your argument by being trustee and beneficiary. But as long as you're doing everything correctly, it's not an issue for you to be
yeah,
both.
the grantor would be someone else and the trustee would not be granting any property into the trust.
Correct. Yeah. The
I,
grantor, their role is very temporary, and they're literally just signing off on the trust indenture and then handing over all responsibility to the trustees.
I understand. Okay, so the next part of that question then is upon the beneficiary receiving the trust, the grantee passes,
Mhm.
the beneficiary receives the trust. What are the logistics after that? Does that trust keeps going, I assume, but does it need to be put into the assets put into a different trust? Or does the beneficiary become, how does that work?
So, thing to keep in mind here is no one owns the trust. So the trustees are like the guardians of it. So the beneficiaries then have a right to benefit from the trust. So the trustees are there, they have a fiduciary responsibility to look after the best interests of the beneficiaries. So once the assets have been granted into the trust, there's no further transfer of ownership unless the trust sells off the properties or whatever that, if it's a home or a rental property or whatever it is. Once that's inside the trust, it remains in the trust unless the trustees decide to sell it off. So if a beneficiary dies,
Yeah,
the ownership wouldn't change. A new beneficiary would be appointed or already be appointed in their place. So it can continue for generations. Does that make
that
sense?
that's the key right there. So the beneficiary receives the trust and appoints a new beneficiary.
Right. But the beneficiary is not receiving the trust. The grantor is creating the trust, who then appoints the first trustee, and then the first trustee then appoints the subsequent trustees. Okay.
Yeah,
And the grantor at the time of creating the trust will nominate who they want as beneficiaries. And then so the beneficiaries don't receive the trust. They don't receive the trust as an entity, they don't own it, they just benefit from it.
I
Okay.
understand. Yeah,
So the legal title of any assets is then it's split between the trustees have legal control and the beneficiaries have beneficial ownership. So the concept of ownership is kind of split, if you like, into legal title and equitable title. So the legal title remains with the trustees, and the equitable title remains for the beneficiaries to benefit from.
but the beneficiary wants this to continue. Wouldn't he name another beneficiary, when he passes? To
Right. So the beneficiaries don't decide anything. Okay. They are purely there to benefit from the trust. The trustees make all the decisions. So if, for example, like a grandchild was born later down the line after the trust had been established, then the trustees could decide to allocate some of the units of beneficial interest to that new grandchild. Okay, so that's how it continues for generations, because each new generation that comes along, the trustees can then add them into the trust.
Okay, that makes sense.
Cool.
All right.
there's other options here as well, and in that you can create sub-trusts if it carries out the purpose and intent of the trust. So if you have, I'll give an example. Let's say you have someone who's receiving benefit from the trust, and they have a child, and now there's a new member of the family that is a potential beneficiary. The trustee could create a trust just for that child to move benefit to them, or some other structure. But the flexibility is certainly there with this vehicle.
Yeah, absolutely true. It is totally down to you how you want to manage things and operate the trusts, and like Will says, create sub trusts. So rather than add all the beneficiaries into one trust, you can then start splintering off because obviously, different family. Let's say you have three children, and then one of those children has no children, one has two, and the other one has four. Well, then that might be a cause for conflict as to who gets what, right? But whereas if you create subtrusts, like each nucleus family has its own trust that comes from the master trust, if you like, so it can stop any conflict. So there's lots of different options, basically.
Okay, so in the chat, we have a question from David saying, is OPPT still active? I think I'll answer that. What OPPT stands for One People's Public Trust. It was established back in 2011 by Charles Miller, and Randall Hillner was the main trustee. And Randall in 2012 traveled to Switzerland and went to Basel, where Bank of International Settlements, the central bank of all central banks, was. And he filed the trust papers along with a foreclosure on the bank, as well as the World Bank and IMF at that time. What did that do? Well, it caused a few earthquakes within the system, but it wasn't visible to the public. The purpose of the trust was to provide a distribution system for when the stolen wealth by the cabal was repatriated to the world's people. Up until then, there had not existed a structure to enable that to happen, and it was decided that this would be the best kind of vehicle, which is what you, ladies and gentlemen, may have today, a natural law trust, written and designed by Randall Hillner and also now Bradley Long. So that same trust design, which the elite have used and Randall and the rest of us have improved upon with suggestions. I've made a few contributions, other intelligent people have made contributions, and it's really a well-crafted instrument today. That became the design for the One People's Public Trust. Your question is whether it's still active. The answer is it's at rest. It's not dead, it's not gone. It's just resting until the right time for activation comes. I just heard from Julian Assange the other day that the White Hats have taken over the BIS. So that's big news. If that's true, then we may be getting closer to the activation of the trust. Okay. Oscar, how will trust stay away from IRS interactions? Either of you gentlemen like to handle that?
I can jump in there. So,
clarify if necessary.
okay, yeah. Do you want to expand on your question then, Oscar?
Right. So, how will trust basically be shielded from IRS? How could the trust have the least amount of interaction or least amount of interplay or interface with IRS? And will IRS eventually be defunct at some point is what I'm getting at. Are you?
So with the trust, the main interaction into the public realm, which obviously is where the IRS is the bank account. Okay, because we obviously need that interface with the public realm in order to transact. If you were to have another trust behind that public-facing trust that was completely in the private realm, then that would add another layer of insulation, if you like. But even without that, the trust itself is completely a complete tax filing exception. So we even have a letter on file from the IRS saying that there is no tax filing requirement for these types of trusts. So as long as you don't do anything with the trust that's then going to put you back into the public jurisdiction, i.e. getting a business license or something that requires that public interface again, then you are kept well away from the IRS. Does that make sense?
Right. Well, yes and no. The yes part is your explanation is clear. On the other hand, I have two businesses that are beneficiaries of the trust.
Mm-hmm.
So do those sole proprietor beneficiaries, uh, do they have to file taxes themselves, or are they shielded by the trust?
No, if they're an LLC or a C corp or an S corp,
No, no,
they'll
no. They're sole proprietors. Sole
right.
proprietors.
Okay. You would still need to do whatever you've always done with those, i.e., file taxes, because they are something that's already on the IRS's radar. Just by making them a beneficiary does not give them that, because they're not an asset of the trust, they're a beneficiary of the trust, right? So they just still carry on business as usual.
That's correct.
Understood. Understood. Okay, very good. So then my last question, because it's coming up in the next few, can we open up a trust bank account without needing an EIN number?
Uh, I'm not aware of any way of doing that.
It's
It's
not necessary to try to avoid the EIN. My dear brother Oscar, you should know that. It's
I'm just,
entirely,
it's only the only reason why I'm saying that is because I predict that at some point IRS will have to go away.
there have been some posts on social media that Trump intends to terminate the IRS. Now, how true that is, we will see. But there's been some serious posts saying that's absolutely one of his statements and one of his goals. So, if so, it's a long time coming, as you know, because the provisions of Nasara Gasara were laid out way back 25, 30 years ago, and they've been taking this long to get implemented. So,
True. Very true. Well, thank you for giving me a voice box. Appreciate you, gentlemen. Thank you for being here.
well,
I
thanks
yield.
for your question. And, Oscar, for the benefit of everybody who may be listening, I can add a little bit that I began using these trusts in 1993. What is 2024? So it's been 31 years. I have not had a single problem ever. Not only that, I've never heard of any trust client using our natural law trust having a problem with any tax agency in any country, not just the United States.
Beautiful.
So it truly is an exception. It's not, we don't call it exempt because that's a statutory term they can give and they can take away. An exception is far more powerful. That means they didn't make it an exception, so they can't remove that uh, absence of liability.
Understood. Thank you.
Yeah, thank you for joining us and pipe up again anytime. Okay, David, will BIC still be able to write trusts for different parts of the world with different jurisdictions? Well, yes, because it is not subject to a jurisdiction. That's what you need to clearly get your mind around and understand non-statutory. So, with sympathy to everyone who has tried to grasp the meaning of non-statutory, Bradley or Will, would you like to illumine that topic? Because people have difficulty. What does that mean, non-statutory?
Can I explain a little bit further, please, Tansen?
Sure.
What I meant, or with the different jurisdictions with common law, I think Randall's talked about in different parts, it's more Roman law and different things for different parts of the world.
Every trust has on page 2 or 3, I think it is, the geographic location where the common law would be used. Yes. However, please understand what that means. It is not the jurisdiction that governs the ability of the trust to exist. It does not authorize the trust's existence, and the trust does not derive its permission under that jurisdiction. You understand? Only applicability of that jurisdiction is in case there is a dispute over a transaction, in which case that local court would be granted limited jurisdiction to rule only on the transaction itself, not on the trust.
Thank you.
Is that clear?
Yes.
It's probably worth mentioning here that there's a significant difference between a natural law trust that we are discussing here and what most people have been familiar with. A statutory trust simply means you're going to a country, or in that case, it is a jurisdiction, a government and asking their permission to exist. When they grant permission, they become a part of that trust and they can withdraw that permission when they desire. Okay. So this is a different trust. It doesn't ask for permission to exist because it exists under the common right to contract, which exists in most every country of the world. Even communist countries protect the right to contract because there would be no commerce. There would be no trade. So that's what we're talking about here is it's a private contract between a grantor and a trustee to take care of a beneficiary. And it's as simple as that.
Thank you so much for that elaboration, Will, because this is such an important concept for everyone to grasp. It's novel, it's unusual. It was dominated and hoarded by the elite, in previous decades, generations. And now in the last few decades, it's been coming out into the use of the average people. And it's a concept that is the birthright of all human beings, really everywhere. Everyone has the right to go into private contract without interference from the government as long as you're not harming anyone by doing it. Yeah. So, Dr. Pamela, who do I contact and how when I am ready to create my NLT after the redemption? How did you originally find out about Brilliance and Commerce? How did you get to this webinar today? And thank you for joining us. It's through that same channel. You just go to the website and place your order in the trust section. If you have any questions that doesn't answer, by all means, click on contact us and send a ticket in, and our customer relations man will give you any further details you may need. But yeah, we'll welcome you when you're ready. Steve is saying, who will be authorizing the trusts?
Authoring.
Oh, sorry.
Authoring. Okay.
I got a couple extra
That's
letters.
Bradley.
Authoring. Okay, go ahead, Bradley.
Yeah. So it's me. I've been a protege of Randall's for a few years now. And yeah, we're still using his trust. And I'm your point of contact to get it all customized to your needs. So hopefully that answers your question, Steve.
And I may add that Bradley is very, very highly qualified. He understands it inside and out and is learning more every day. And he's adding a tremendous value to our client servicing with a bit more younger generation expertise and technical things and computers and clear, beautiful language and focus to detail, as well as a good heart. And I just want to put in just a quick mention that Bradley is a trustee of a child-led school in Latin America that is teaching children the principles of sovereignty, using some principles, I guess, from Montessori and Waldorf, but independent and sovereign in its own way as well. So the whole field of education from children to adults is Bradley's field.
Exactly.
Okay, Dr. Pamela is saying, or no, let me get to Ross. Okay, I didn't mean to miss yours. If a homeowner wanted to transfer that title into an NLT, would they be required to pay the normal land transfer tax and continue to pay property taxes every year?
Okay, well, unfortunately, the trust doesn't allow anyone to avoid property taxes. There's different remedies for that, which I'm sure Tanzan can expand on. But if you're going to transfer your property into the NLT, you can do that with a quitclaim deed. But there's no federal law that says that you have to file that quitclaim deed with the county. So therefore, you're not going to trigger a tax event. But
No
should
federal,
someone,
yeah, no federal law, no state law.
yeah,
So Will and I have talked about a lot about this, and it's still a work in progress to study all the details of it. But thus far, we've landed on a couple of contacts. One is, you don't need to file it with the county recorder. And if you don't file it with the county recorder, well, then how is the property tax going to be levied? And if you want to prove ownership, keep the bill of sale and also post it perhaps on a UCC1 financing statement. Well, yeah, any more?
It really depends on where this property is located. If it's the United States, each state is slightly different in how they handle that, but there's generally a commonality. If it's Canada, UK, some other country, it can be different. If you are transferring the title into the natural law trust and you want it to then be the owner and you want that registered on the records, then you would file that, but it means the trust is now paying the property taxes. If there's a transfer fee, which there is in some countries, then that would also have to be paid. In the United States, there's not a transfer fee. So it's a little bit different here. A quitclaim deed could be given to the trustee of the trust for the property, and that would be up to the trustee whether or not to register that. I'm using the word register versus recording. 100 years ago, recording was the methodology, and it would be put on the records of the county who the ownership was. It started in the 1920s when they began to move into registration. That's a very different animal that you need to learn about, because when you register a deed with your county, I'll just use this as an example, your county recorder's office, anything you register, you give to the county. It's the reason they can charge you property taxes. It's also the reason they can take the property from you if you don't pay those taxes, because they're really the real owner. Okay. So it depends how that's done. If a deed is handed to a new owner, in this case, let's say a natural law trust, it's up to the trustee whether he's going to register, record, or simply put it in a safe. There's no law that requires the recording of a deed. In the United States, there isn't. So it's up to you. How are you going to do? If let's say you're the owner of the property, you could go to the county and say, I have sold this piece of property. Here's my bill of sale. I don't own it anymore. Well, that's fine. What are they going to do? You can say, hey, remove me from the property. I don't have it. Then it's up to the county to figure out what they're going to do. But if nobody comes in to register that deed, there's nothing they can do. They cannot send you a bill because they can only bill those that are registered. So each state's slightly different, but that's generally how it functions. I hope that helps.
You're on mute, Tanzan, I think.
Yeah, sorry. Thanks very, very much, Will, because that clarifies it a lot. And I'll just add that the benefit of transferring a property into the natural law trust, whether it is set up to be recorded on the county and be subject to property tax or not, the benefit mainly is that any liabilities against you, the individual, could not be satisfied by accessing the real estate property in the trust. It's in a separate legal name. So let's say the property is worth $1 million, and let's say somebody says you owe them $1 million, and you'll say, I don't have it. And it's true because it's in a separate legal name under a separate government ID number. So if it's in the trust, it is asset protection. It means no one can get at that property to satisfy personal liabilities against the individual. Oscar, did you have more you wanted to say on that, or?
Yes.
Sorry, go ahead.
Sorry about that. Will did a fabulous explanation of the technicality behind register versus recording. I concur with that 100%. And when it started and all of that, I think both Tansen and Will explained this subject matter beautifully. There's one thing I did want to add that I think is really pertinent to the conversation. And that is that the ultimate goal is to have an allodial title of the property. By
Yes.
having allodial title, that means that we have complete total ownership. Now, that's on the ownership side. If we want to protect our ownership within the trust, then that's a double bonus. So I just wanted to bring that up. So I'm looking at number one, obtain an allodial title, unrecord your property or unregister your property, and have your real property reclassified as private. And how do we do that? Through the trust. So with that, I yield.
Thank you. Okay, Ken, you have your hand up. You want to say hi?
Yes, thank you, everybody. This is fantastic. I've been kind of amateurly studying trust for quite some time, and I must say that when I come to this call, that you guys seem to have a much more comprehensive perspective than a lot of the other calls that I've been to. And I just wanted to clarify, I think what Will was just saying is I clearly understand the difference between recording and registering. And so I'm thinking particularly about a friend of mine who has a property. It's fully paid off. It has been probably registered, and she eventually will want to be handing this property down to her son. But right now, the son is probably not really in a state where he's would be able to take on the responsibilities. So for her to put that into a trust, and I'm assuming she would notify the county that the property has changed ownership. But from what I understand, you don't have to indicate who the new owner is, and then at which point that takes it off the county assessor rolls. Do I have that clear?
Will?
Yes. And the short answer is yes. The recipient of the deed, in this case, it would be the trustee of the trust, in your example, would, if he doesn't go to the county to register that or put it on the, then it's not there. He may put it in a safe to keep it safe. There's no law against doing that. In which case the county can't do anything. They can't send a bill to that. They can only send a bill to a property that's been registered in their system.
So
You
if for
see? So if it's been transferred to a new owner and that owner doesn't register, they can't stop that. There's nothing they can do.
so is
They can
the
try to find out the owner. Maybe they can try to find, well, who is this trust? Who's the trustee? And they can try to contact them, but there's nothing they can do unless it's literally recorded. Do you see what I'm saying? Unless you went through the whole process. So essentially, it's a way of removing it from the books. Technically, I guess you could say that, because the result is the ownership changed, but the new owner chose not to record.
so essentially what you're saying is the action of um, kind of notifying the county that the current owner is no longer the owner, and the action of then conveying to who is the new owner are two totally separate steps. And those two steps do not have to be linked together. Is that what I'm
No,
hearing?
they don't have to be linked together. Now, if you go through let's say you went through a title company in your particular state or county, that title company is going to be forced to go and register because they're told if you don't do this, we pull your license.
Right.
Okay. So they're in a problem. But if the document transfers privately, well, there's nobody making anybody do anything. It's a choice. And I have yet to see a law that requires the recording of a deed. One doesn't exist to my knowledge.
And so, from the paperwork standpoint, it sounds like it could be just a very simple notice of kind of de-recording
Well,
of.
there's other ways of doing this. Like I heard of a guy in C that he put an ad in a local paper for 3 weeks saying talking about his transaction that he owned it, but it wasn't recorded. But that gave him public recognition of the transaction. It was certainly an interesting concept. I never thought of doing that, but that was his choice. It's what he wanted to do.
Yeah, well, I've heard about people doing that in libraries and other public places as well. So, well, thank you for that. I think there may be some more questions, but probably make more sense for me to contact you privately on that.
Well, thank you, Ken.
Absolutely. My pleasure. Thank you. I
Uh,
yield.
David, you wanted to say more?
Yes, please, Townsend. So with there's no law requiring to register, or if say a tenant was to get injured through the property and they wanted to do a lawsuit, but there's no recording of who owns it, what would happen?
I guess nothing.
It would be pretty difficult to do that if they couldn't prove who owned it.
Yep.
The court would be like, show me evidence, and there isn't any.
Would they then so try proceed through through a property manager for the ownership?
Well, they could do that. Let's say the trust owns a piece of property and it's a rental and it's rented out to individuals. Could those individuals sue the trustee or behalf of the trust of the property? They have information of who the owner is. So for them, yes, they probably could engage in that. And they can say, I've been paying rent to them, so they are the owner. So in that case, yes, uh, that would probably be verifiable evidence to a court who the owner is, even if it's not recorded. So I realize I'm not a lawyer, so I don't want to get into the legal weeds, but I just wanted to talk about the generalities of how you approach that. The trust doesn't eliminate your ability to make good decisions. You still need to do that if you want to have good outcomes. Would you agree, Bradley? I think
Yeah,
that, yeah, you
absolutely.
still need to make a good.
Common sense should always prevail.
Absolutely. Absolutely. And that's why we say these trusts are for peaceful people. So far, so good. Knock on wood, our people have stayed out of trouble. Dr. Pamela, you're asking again, should new homes and properties be put in a separate trust from the financial assets? Absolutely, yes. The cardinal rule of asset protection is never put all your eggs in one basket.
I would agree with that. And particularly when it comes to real estate or homes where there is a potential for liability if others are on the property, you won't want that liability being exposed to other assets. So separating that is always a good idea.
Okay, Brian is asking, I'm new to all of this, and I apologize if I'm asking a question that everyone else already knows. If I wanted to put my physical gold and silver in an NLT, will I need to send my assets to a holding location? No,
No,
no.
just list it on the Schedule A in the natural law trust as an asset of the trust, and where you hold it is entirely up to you.
Exactly. You could even put a copy of the ownership document or the SKR into the trust notebook and computer records.
Yeah.
Craig is asking, do you recommend getting, for example, a declaration of NLT document only recorded within the public jurisdiction in one's local city, county, or township? Or to your earlier point, we'd want to stay away from that type of action to insulate our NLT from public jurisdiction.
Yeah. We recommend that clients notarize the documents so that there is a record of the and a witness of the signatures, but we make a notice underneath um, the notary seal saying that basically by using a public notary, there's no way enter this trust into any foreign or public jurisdiction. So we're even though we're using a public notary, we are keeping it well within the private realm.
It's not subjecting the document to the notary's authority. It's just the witnessing of the signature to prove that it was executed, it was signed. Yeah.
Right. Yeah.
I think it's important for people to understand that um, the point of this is a private vehicle to be in the private space. So you have to be careful how you interact with others that you're not by choice public jurisdiction that then makes you liable for some other things that maybe you didn't intend. So it doesn't take away the responsibility of a trustee to make good choices to keep that in a private domain. Would I go and as you say, post it and make a public? No, I wouldn't do that at all with one of these. Um, that's just my recommendation because I believe that a private document should remain private.
And my question is, what would be the point? What would be the benefit? You're not looking for police protection, are you? Because, yeah, like Will said, that would be clearly crossing over into the public realm, and then you're subjecting yourself to all their rules. So, yeah,
Yeah, I think a common question that I hear a lot of people ask is maybe Craig's coming from the point of view of like trying to legitimize the trust.
right.
It goes back to what we were saying earlier, which is like, it's based on our inalienable right to private contract. It's not subject to any particular jurisdiction. So, yeah, you don't want to volunteer yourself into a public jurisdiction.
It's inherently legitimate. Oscar,
Yes, thank you. So the question is about jurisdiction uh, in regards to, let's say we have a business and it's on a major boulevard within the city, and the city wants to start putting all its jurisdiction all over this private trust NLT business. Um, how does that interplay? How does that work out?
It works perfectly fine to have a public entity that is the face to handle the public business, but that ownership of that entity could be private, such as a trust.
Okay.
If you're trying to, in other words, you have to differentiate those. Now, let's say it was an LLC that is the face of the business on the street and it's interfacing with the city. You can do that and still have the ownership of that LLC held by a trust. And they each in their own jurisdiction separately. I hope that helps.
Okay, so does the NLT business still require a business license within the city?
If you're in a business that requires licensing, you're in the public domain. So if you're in a business that says, okay, I need to have a license with a city or county in order to engage in this, I would suggest you use an LLC or some other vehicle like that as that face, as that public face. But you can still hold ownership privately in a trust.
Right, because there's been also a lot of discussion about PMAs, the private membership associations, and setting that up as the business front so that the city doesn't have jurisdiction to interplay. Is there truth to that?
it's similar to the trust in the sense that the PMA is another private vehicle. But like Will said, if you're a brick and mortar business interacting directly with the public and selling products or services that would normally be have a sales tax, um, I really don't know how you would avoid that. I think the LLC idea is a good one, and up to 95% of its assets and income could be owned by the trust, so very little tax would be owed. This issue came up recently, and I sent one of our correspondents a document that I created originally for Washington State and then later for California, answering the Secretary of State who wanted to know where my registration of my business was because they wanted to, charge sales tax and all that. Of course, Washington State doesn't have an income tax, but they do have sales tax. Well, I wrote a letter back saying, we're online, internet, worldwide. We have no employees in this state, have no employees at all, anywhere, actually. Only have independent contractors, and they're in other states. Um, it's a private ownership under a private trust. And this is about brilliance and commerce. Um, it's not actually selling products and services on the street, to the physical public. It's only in cyberspace, digital or intellectual property. Never got an answer back. They gave up. They basically said, I guess they were satisfied with that. I didn't hear back from them.
Mm.
That's why Brilliance and Commerce doesn't charge sales tax. But I had other people correspond and say, well, I do have a brick and mortar business. It's on a street, it's on a boulevard, it's, you know, got people walking in off the street and, it's expected to have a business license and pay tax. There again, it's like registering your real estate. If anyone has any experience with operating a business like that and not registering it with the local city or county for a business license, let us know what your experience is.
Well, yeah, that's exactly what I did is 2 years ago, I revoked any corporation status, whether it's S Corp or LLC. I revoked them and converted to a sole proprietor and then converted the sole proprietors into the NLT as the beneficiary so that the NLT becomes the firewall. And
The NLT is the beneficiary or the owner?
the NLT is the owner.
Okay. So if the
Um,
is the
yeah.
owner, did you ever get a business license for your business?
The city wanted me to, but I was able to contest the city to let them know that they are a corporation and that they're not a government. So therefore, I'm not um, in contract with them.
And that was the end of that?
That was the end of that. So I've been operating without a business license for the last 2 years.
Well, thank you. Thank you, Oscar. So everybody, see, I don't operate a brick and mortar business, so I
Yeah.
didn't, but that's the
I'll get
answer.
on camera. I'm in my castle.
Oh, there you are. Wow. You're the prince of uh, the Temple City Council Palace, I guess. Castle.
Yeah. It's good to see everybody.
I want to thank you for that answer because that'll help a lot of people.
Well, I have to say that it takes a lot of confidence and courage and also naivete. We have to have a little bit of all of it to step forward and not be endoused with fear. We have to say, okay, I have enough knowledge to say I know that the city is operating as a corporation and that they shouldn't be acting as a corporation. They should be acting as an unincorporated service to the people.
Yes.
So one part is patriotic, one part is constitutional, and then the other part is saying that I want the city to do what it's actually designed to do, and that is to service and support our prosperity as a nation. So I kind of take on that um, constitutional position is where I stand prior to 1860.
So,
So
Oscar, you operate a dance academy, right?
that's correct.
And you probably then don't charge any sales tax on your classes, right?
No sales tax on classes, but sales tax on dancewear and paraphernalia, that type of thing.
I see.
Yeah. So we pay the sales tax, that's okay. We pay the sales tax. I think that should suffice.
But you don't operate with a license, a
No,
business license.
no,
See,
no,
it's
because
like
a
they
lot,
chose.
why I have the right to prosper and do business as long as I'm not hurting anybody and I'm not stealing or doing business in corruption, you know, a conspiracy of sorts. I'm doing things above the table. I'm doing things under God's law, biblical law,
Natural law.
natural law.
Yeah. Okay. Thank you. That's a valuable conclusion and success story. And
Okay.
you will have ever more to share, I'm sure.
All right. Well, thank you. Thank you for bringing me on board. I appreciate it. And Will, wonderful to see you, Will.
Thank you,
And
Oscar. Good to hear from you again.
absolutely. And Bradley, thank you for being on board and being of service and looking forward to more of you. So with that, I yield.
Thank you,
Thank you,
Oscar.
gentlemen. Thank you.
Uh, Dr. Pamela put up a question that I think applies to a lot of people. If you collect interest on an investment into a trust bank account, does one still have to pay taxes on the earned interest? The question is the entity earning the interest a taxable entity? If they are, yes, they would. If they are not, no. That's my answer. You can consult with a tax, attorney or somebody on that, but it comes down to, is it the trust paying the taxes? Are they a taxable entity? Can taxes be collected from them? If they're an exception and they're not in the system, I don't think it matters. But like I say, you could always talk to a tax attorney on that question.
Exactly. So the asset depends on who owns it. Does the trust own the investment? If the trust owns the investment, the interest on that investment would not be taxable. If some other entity owns the investment, then it depends on that entity's status, whether it owes tax on its interest payments. Very simple. Okay, Bo, do you have to assign, redistribute UBIs or TCUs to a trustee or exchanger who wants to transfer to an asset into a trust that was created a year ago when the original assets were added into the trust? So for the benefit of everyone listening, a UBI is units of beneficial interest. So that's what the beneficiaries receive in the natural law trust. Or TCUs are trust capital units, which are like shares of stock. So those are only used for, you might say, businesses that have a lot of people involved and want to divide like shares of the trust assets. And he continues his question, can I, as the trustee, just move assets into the trust without redistributing UBIs or TCUs as long as I don't want the assets back and prepare the ledgers, minutes, and transfer of title paperwork properly?
Absolutely. I would say if you want to exchange something into the trust and you don't want TCUs in return for that, that's totally at your discretion, Bo. And it doesn't mean it changes any of the UBIs for the beneficiaries. They can stay as they are. So it's just a simple exercise of recording a minute to make that decision to acquire that asset into the trust, and do the everything we talked about earlier with the quitclaim deed into the trust name. As simple as that.
Thank you. Very good. Simple, clear, and to the point. Ross is asking follow-up question. If one doesn't register transfer with municipality, how does one prove ownership?
Who has possession of the deed? If you're the one in possession of the deed and it's assigned to you and you're the trustee representing the trust, well, that's ownership. pretty simple.
Well, to extend that a little further, how does one prove that one has that in one's possession? Is there a public way of
That's
doing
a
it?
good question, and that might lead to the reason that this one man, as we talked about, took out an ad in a paper to
Yes.
prove his point. He didn't register anything, but he did take out an ad to let everybody know the transaction occurred. That's public. I guess that's proof.
I also think that posting it on a UCC1 financing statement with the Secretary of the Treasury could work, or Secretary of State. Ken, you wanted to say something to us?
Yeah, I was kind of wondering if you just put a notice saying that a deed to that property does exist and you recorded that, then you could validate the existing of the deed for the property without giving away the actual property owner. Would that make sense?
Yes, and without posting a copy of it, because with all the cyber criminals out there, they could take that and make it into a forgery. So you wouldn't want to give away the actual image of it. But like you say, you could make a claim that you have it in your possession.
Yeah, and if you put like I mean, you could do a couple things. You could put a postage stamp on the upper right-hand corner, sign across it, sign across the stamp at the bottom, get it notarized, do all those other various things to kind of validate it as an original.
Right.
And then you hang on to the copy. That might be a clear, simple way to do it, along with the one that you mentioned as well.
And you could honor the privacy by staying in the private with it, keeping it in your safe, like Will said. And if you were ever challenged, it might get into a court, a local court, in which case you could bring the original in and they can authenticate it. Then it would confirm in the public, if it were absolutely litigated and necessary. Otherwise, you just keep it private. Yeah.
Yeah, exactly. Follow-on question is, you were, as I was talking earlier about putting a house property into the trust and not recording the new owner. Obviously, that would be removing it off of the property tax rolls. So I assume if they did want to have any private contract with, let's say, police and fire and some of the other services, that's what they would do, but that would be a private contract in that case.
Yes. How would one avail oneself of those services?
Yeah.
Uh,
Eh,
that's called being sovereign and independent. You would have to have an agreement with those agencies. That's part that the county says this is why you pay property taxes so that we can do this. Although very rarely do people avail themselves of fire and other services. So um, that's that's the argument. If you wanted those services, then yes, you could probably work some agreement out, maybe even do a direct agreement if you wanted to with a fire department. Otherwise, you need to take care of your own fire.
Yeah.
Yeah. Well, I'm just kind of thinking of the personality of the people involved as they would be a little bit, you know, very cautious on not having that type of protection. So bringing those contracts into the private certainly would be a very easy remedy for something that they wanted to take on.
Now there's other considerations that happen here, and one of those may be challenges with getting insurance on the property if it's not recorded. Some insurance companies are real picky about that. That's a whole separate issue, and we're not going to be discussing insurance tonight, but all of those things factor into the decision-making process.
Yeah. Yeah, I could definitely see that that would be or could be a very major issue because obviously you're dealing with liability and people kind of want the lowest uh, the simplest, most convenient method. But yeah, those. So it sounds like that in that situation, insurance, police, and fire would really be the primary concerns of taking something off the property tax rolls.
Okay, well, thank you.
I agree. It's certainly something to consider.
Excellent. Thank you all. Thank you very much, and I yield.
Thank you. David is asking, is Dominique Hackett still with BIC? Is she still doing study groups? The answer is yes, but only in the capacity of trust accounting. She's working on a trust accounting book and is making herself available for trust accounting consultation. But she doesn't write trust. She's not offering trustee services or any of those things. So I hope that answers your question. Ashok, nice to hear from you on the show. 501c 1A, does putting a real property through this mechanism avoid property taxes? And what other ways are available to avoid property taxes? No, putting it into a 501(c) or C1 is a charitable organization registered with the IRS and has to file every year. Don't recommend it. Lots of headaches, registration fees, long reams. I know friends, I've known friends closely who ran 501(c)(3)s, and they are complicated, lots of work. You have to have meetings, you have to have resolutions and minutes kept. It's a lot of work for what? For what benefit? It's not going to protect you from property tax. So, what other methods?
Nonprofit organizations pay property tax like everyone else.
Right.
There's no way around that. You just have to know if you're moving into the private realm of being responsible for your property, you may be solely responsible. That means you may have to be self-insured and even have your own fire protection. So everyone has to make in the decision-making process. So I hope that helps.
Yeah. Ashok, we were discussing all of that earlier, but let's get back to the trust. So David is asking, is it best to buy property in your own name, then go through the process of placing it in a trust? I would
if you can avoid, sorry.
say no. If you can put the money into the trust and have the trust buy the property, that's better.
Yeah. The only reason you would do that is if you needed to get finance to buy the property in the first place. It's going to be easier to obtain finance in your own name than it is the trust's name.
True. And then if you're going to have a mortgage, you can transfer the title of ownership of the property into the trust, but the mortgage will follow it. So it won't exempt, the trust will not exempt the mortgage payments, from paying the mortgage payments. So, but if you can have enough money to buy the property outright, best if the trust buys it and pays for it from the beginning. Ashok says, do new Schedule A need to be created each time a bullion property is conveyed to the trust, or just a meeting minute for going forward, acquisition and conveyance hold good?
The most important thing is to keep the minutes for every acquisition, but you can keep a running Schedule A as well alongside that so that it's recorded on a schedule. But the minutes are the things that you're going to have to rely on ultimately.
You just add the item into Schedule A and create a separate minute.
Yeah.
So everyone, a minute is a page that goes into your trust, or maybe multiple pages on each transaction of any significance. And templates are available. For those who don't already have a natural law trust, templates are provided and guidance is provided by Bradley. Greg is asking, hi, I came in late, sorry. Is there a difference between a common law trust versus a natural law trust under the Republic? And if so, what are the differences?
Okay, so a common law trust is exactly that. It's governed purely by common law, whereas a natural law trust is something that sits, I like to describe it as like a ladder or an ascension of laws. So you've got legislation and statutory law right down at the bottom. At the very top, you've got natural law or God's law whatever you want to call it. So by being at the very top of the tree or the top of the ladder, it sits in a higher realm, if you like. So that would be the most obvious differences. When it comes to the protection that it provides, a common law one is only within that jurisdiction, whereas the NLT operates in the natural law jurisdiction, which has more inalienable rights. I don't know if you want to expand on that, Tanzan.
Perfect. No, I mean, we observe how many imperfect common law trusts are out there that make mistakes, that endanger people's assets, that are not written correctly, and they call them common law. So we needed to come up with a different designation to distinguish the quality of this particular trust, even though on page 3 it does say it invokes the common law of a local geographic jurisdiction, because that's what courts understand, limited jurisdiction for transactions only. But the authority under which the trust is created is contract law. And contract law is not only natural law, it's a universal law. It's also the one law that is honored in all countries amongst all people, and most, if not all, governments and Supreme Courts, as well as the Uniform Commercial Code, which is global. So contract law is the basis, the right of everyone to go into private contract with each other without interference from the government. So natural law then means doing things the right way. Don't steal, don't harm, don't take what isn't offered, don't lie, and if you make an agreement, keep your agreements. Those are the basics of natural law. The vibration you send out comes back to you. You sow what you reap, and that's why I think our people have stayed out of trouble. If they're attracted to natural law, they're more or less most likely living more or less according to natural law, and therefore can operate an instrument. We would say it's self-governed, meaning you are governed from within, and you derive your sovereignty from your divinity within yourself. And if you operate yourself that way, you will most likely operate a natural law trust successfully that way. That's why I think Bradley and Will, I think a lot of our supporters and clients and people who understand and operate this kind of instrument are among the cream of mankind, really. Reggie's asking, can you take money from a regular W-2 job and place it in a natural law trust account for protection? Yes, absolutely, of course. However, there's a better way if your boss would agree with it. And that is, if your boss would agree, convert your status from an employee to an independent contractor, in which you tell him, I will do the same work for the same pay, everything will remain the same, except I want you to pay this trust, my salary, instead of me personally. And here's an affidavit that I've signed under penalty of perjury, notarized, guaranteeing you that by paying this trust over here, you will have satisfied your obligation to pay me my salary. And if it's a small business, he might say, okay, no big deal, he'll sign it. If it's a big corporation, probably not. They probably wouldn't be willing to do it. So that would be best. If your salary goes directly into the trust, then you won't have to file any income tax on it. But if he pays you personally, and then you turn over that money from your personal account into the trust, yes, you can certainly do that. It's just that it won't protect it from income tax because it would be paid to you in the first place.
Well said, Tonson.
David is asking, is Will holding another update Zoom call, please?
Yes, next week.
The 21st
21st.
of November. Yes.
Next week on the 21st. Yep.
Yes, it was in the same newsletter that you got this meeting attendance link from, and I'll send it out again probably Friday or Saturday. Lynn saying the latest BIC newsletter has it listed November 21st. Yeah, right. Thanks, Lynn. Thanks so much, Will. Rich, how do you stop paying FICA taxes in the United States? This is not a intended to be specific.
Stop signing W-4s.
Thank you. I
But
mean, getting a little off
when
topic.
you go to work for somebody and they stick that paper in front of you, it's a W-4 with a signature at the bottom of it, that is a self-admission that you are a taxpayer in their system.
Yes.
Now, some companies will work with you on that. Like Thompson said, there may be a ability to work with you. Others will just look at you like you're crazy, and then they may not work with you. So, good luck with that one.
Thank you, Will. Very, very good. Bo is back. He's saying if you create an asset holding trust with no bank account and you have a management trust with a bank account, do you recommend the management trust be the primary trustee of the asset holding trust along with an adverse trustee? Or is there a better, smarter structure when the management trust pays expenses for the asset holding trust?
So just keep in mind that the trust being a trustee is an entity, right? It's not a living, breathing person, man or woman. So from a practicality point of view, you've got another layer to go through there in order to get decisions made. My personal view is just to keep it simple, right? And just have a management agreement between the trusts that the asset holding trusts, banking requirements are taken care of by the banking trust effectively. And then whatever transactions need to take place get done, and it's all documented and minuted. So my personal opinion is it doesn't really matter who the trustees are. It's just about the control and the relationships between those people, as opposed to one being better than the other in terms of the structure, if that makes sense.
I thought that was well said. Thank you.
Makes sense to me.
Good. And I can answer this next question from Oscar. If you message, send a ticket in or whatever, I can send you the templates for the minutes. If you've already got a trust, no problem.
Yeah, and on the Schedule A, it does make sense to have an open Schedule A and add minutes onto that. I think that makes sense. I personally choose to, if it's different asset types, if it's going to be the same asset type, I think you could do that. But if it's different asset types, I like to, so that there's clear distinction of what that asset is, that you're bringing into the trust. So
That makes sense.
Gail says Bradley seems to be a wonderful addition to the BIC family. I agree.
Thank you, Gail.
What I find fascinating about this trust is observing the long-term view that, we see changes all the time in the world, right? Politics change, banking, all kinds of things are going on. And I've heard that prior to Randall, there were mentors before him going back 5 decades or more, that this trust design has withstood the changes of time. And not only that, but changes of jurisdiction or changes of geography, you might say. So you have a single formula for asset protection that works worldwide. And maybe in some countries they don't understand it as much. The banks may not cooperate as much. But basically, more or less, it is universal in application and enduring over time, so that no matter what changes in politics, in laws, in legislatures, in parliaments, in congresses, whatever changes in local laws, municipalities, this trust idea of the right to enter into contract will continue and continue generation after generation. And I would dare say, even into if there's a golden age when crime has disappeared from the planet and you don't need to protect your property from thieves anymore. It will still serve as a very efficient estate planning tool for the efficient distribution of assets and the bequeathment of, is that a word? The bequeathing of assets to the following generations. So it will still be useful, I would say hundreds, even thousands of years from now.
Well said. It really is that longevity, that's important, right? Times change, the natural law trust doesn't.
Larson is saying, can you explain how a trust can own and operate a business?
Yeah, absolutely. So the trust can, you've got a choice to make. If you've got an existing business, as we touched on earlier, you've got a choice whether to continue having that business as your touch point in the public realm and then have the ownership of that business within the trust. The other alternative is to dissolve that existing business and transfer all your activities into the trust. So that's very much a personal decision and depending on the type of business that you've got. But the trust can absolutely operate as a business. That's not a problem at all. Doesn't mean to say it's a business trust. It's a trust that's operating in commerce, so a natural law trust that's operating in commerce. Because you don't want to have a business trust, you want a natural law trust conducting commerce. There's a subtle difference there. But totally legitimate and fine to do.
Thank you. Seth is saying 26 CFR 602.602, 601.602 says the income tax system is under voluntary compliance. Try showing this to your employer if you need to. Okay. And Seth, I wonder if you've done that. Oh, no, you don't have an employer. You're a boss of your own, I guess. But anyone who has an employer, try showing that. And they'll just probably smile at you and keep on, because they're more afraid of the IRS than they are of you. He says it also applies to independent contractors and sole proprietors. Thank you. A good point. Ken is saying, Rich, you can use equity processes to discharge the mortgage in full because Rich's question was, is there a way to get rid of your commercial mortgage but still keep the property? And I referred him in the chat to send a ticket in on our website, click on contact us and ask that question, and Peter will give you the answer. We outsource that to a firm in Arizona that helps people cancel their mortgages and get their property free and clear. But Ken is also saying you can use equity processes to discharge the mortgage in full, but it may take some time before it gets executed, and there's always the threat of foreclosure in the process. So anyone who's interested, send that ticket in to our customer service, and we will refer you. We don't get any commission or any part of the transaction or anything like that. It's just a public service out of the kindness of our heart. Because we're concerned for people to keep their properties. And this firm in Arizona does put people through a process. Now, they can charge $10,000 and more because they have hard costs. They mastermind a process with attorneys, title search, forensic evidence, paper trail, all of that. And they construct a strategy for challenging the existence of the mortgage. Which of course, pretender lenders cannot prove. So far as I know, they've had pretty close to 100% success rate and kept people in their homes. Let's get back to the trust. Bo is saying, does an asset holding trust have to pay for the services of the management trust? In other words, a monetary exchange for services to legitimize the contract between the two. The asset may not generate income, but only expenses.
No, there's no obligation to do that. If you wanted to make the exchange an ounce of Troy silver or something, then you can do that. But just so something's down on paper, but the contract can exist without any monetary value. That's absolutely fine.
Larson is
I
asking,
agree. Keep it simple. Keep it. Nobody's coming to look at your books. This is a private trust, so your methodology of handling that can be handled easily. You don't need to. You
Yeah, good point.
certainly should not be in a situation, if you're doing this properly, where you need to open your books to an outside entity.
and that is how the super rich do it. They don't
Mhm.
subject themselves to any more monitoring or compliance than absolutely necessary. Larson was saying, will there be any affiliate training? Yes and no. Yes, there's a robust library of affiliate training documents in your affiliate library if you've registered as an affiliate with BIC. But the answer is no if you're asking about live training like in person or on Zoom or anything like that. No, we don't do that. But it's all in the written records of your library, your marketing materials. Gentlemen, we're getting near
Well,
the
this has been a great call. It's
yeah,
good to talk with you, Bradley, and everyone. Great questions. I think
Yeah.
hopefully this was helpful for everyone.
absolutely. In conclusion, would you gentlemen like to elaborate any more on statutory um, or non-statutory and how help people understand what that means?
Stay out of the statutory.
And why is that?
Because you're volunteering yourself into a system that you don't need to be part of. So, as Will touched on earlier, if you were to go and open a statutory trust, the government is a party to that trust. Whereas what we're doing with the natural law trust, we don't need anyone's permission to create that trust because it's based on the right to private contract. So if you want to keep your affairs private, keeping it private is the way to go. But if you want headaches from the IRS and the government, then go and see your lawyer and attorney, and they'll volunteer you into that system with a statutory trust.
In other words, the question goes back to anyone who may ask, where are the benefits that you are getting from a statutory compliance instrument or system? Most of us have observed that there are more benefits by operating outside that system than there are liabilities. Any
Absolutely.
any final comments, Will or Bradley?
No, just thank you very much, everyone. I've really enjoyed it, and yeah, looking forward to the next one.
Larson is saying, can you recommend where to get an understanding of exchange versus income?
In what context?
Yeah, maybe Larson, you could elaborate on your question if you want to unmute.
Thank you. Yeah, I'm just trying to get a better understanding of, when you provide, I mean, I'm just trying to get an understanding of how to define what is income. Um, it's not income if I exchange a service for you, like if I'm providing a service and you give me something back, that's not income. Or I'm just trying to get a better understanding of when it should be called income versus an exchange for claiming it as especially for tax purposes, if I'm saying that the right way.
So you're talking about
Income is a term used in tax law. So if you're using the term income, it means you're referring to taxes. You don't have to trust. You can simply have a small agreement, could even be within the minutes, that you're going to do X and the trust receives X. It's a very simple thing. It doesn't have to even be a monetary exchange. You don't need to show that to anybody. That's simply just records for the private trust.
Thank you. I just didn't know if there was some place to go to like get some better reading or understanding, but thank you very much for that.
Right, Lawson, you don't need to concern yourself with the IRS definition of income because you have the opportunity to go on the BIC website under resources, scroll down to freedom from tax. Number one, you will see there is how to make yourself individually in your personal name exempt, 100% exempt, not exception, but exempt from the income tax for the rest of your life. It's had a 100% success rate. It's been authorized by Congress. It's the revocation of election. You are revoking your election to have volunteered into that system. You have the right to revoke it. And it's done with the right wording. It's a one-time action you file with certain agencies. It doesn't cost anything except certified mail postage. And so that instrument officially places you in the proper places in the government documents and databases as a state citizen, okay, as an American sovereign. And you therefore have no more concern about filing tax returns in your personal name or being concerned about whether they define what you have as an exchange or as income. You no longer care how they define it. It doesn't apply. It doesn't matter. So any commerce you put through the trust, of course, is already an exception to any filing or paying laws. But the revocation of election can also make you exempt in your individual name. And it's a good thing to do for trustees because if you yourself are documented sovereign and exempt, it helps you to understand and operate that way when it comes to the trust.
Thank you so much.
You're very welcome. Seth is saying statutory jurisdiction is such as United States Code or Code of Federal Regulations or your state's general statutes. And that would apply really much in any country. The government laws passed in parliaments or legislatures, wherever you are. In the United States, they are corporate policies and not really law. To operate any public vehicle, such as an LLC or corporation, is to subject yourself to these jurisdictions, or at least to subject that entity, I'll say, making you liable to follow all of their laws. NLTs operate outside of these jurisdictions by existing only under natural law. Correct. So thank you very much for that. And Mato's saying, does that apply to state tax as well? Yes, of course. If it's an exception to any kind of statute, then it's an exception to state statutes as well as federal.
I think he might have been referring to the revocation of election.
Yes.
Yeah.
Well, it applies to the trust as well, doesn't it? Yes, correct. Yes, both. And Jay, Swees, Marianne, you're saying not a state citizen, rather state national. No, you are absolutely wrong about that. You need to go to the BIC website, click on resources, scroll down to freedom from tax, go to number one, and open it up and read it. And you will see how the state and national idea is a scam. And you'll see proof of it in there. I'm giving you a severe warning. Stay away from the so-called national. Look up the word national in the United States Code. What does it say? It says if you are a national, you are someone who owes lifetime allegiance to the state. What better definition of a slave can you get? Stay away from the word national. I'm sorry, you got it wrong. You better go and read that article in number one under freedom from tax, okay? For your own protection. David says, does revocation of election remove you from receiving Social Security, Medicare, or any of those types of things? No, it does not. It only improves your status. It has no downside.
Thanks for posting the link there, Bradley.
Yeah, no worries.
Thank you, Bradley. Yeah. Okay, we've had a wide-ranging discussion. Thank you, everyone. Interesting, fascinating. We had a very good group today. All right, so join us next week for the Will Barney show on November 21st. It'll be the last one of 2024. We've had a lot of exciting things happening in the world in the last week or two, and there'll be a lot more even by next week, I'm sure. Yes, Will?
Oh, there's so much to talk
It's
about.
moving so
All
fast.
good, right direction. And the awesome thing is now everyone can see it, right? We're not just talking about it. Now the evidence is all around us. So it's going to be cool. Well, I'll put together a slideshow and next week. Thank you.
Fantastic. Thank you. It was in the newsletter that this webinar's information was in, but I will send another special one in a couple of days announcing the Will Barney Show. Thank you, everyone. It's been great speaking with you. Please join us again in January for the next trust event and follow your heart. And Bradley, thank you so much for your debut and meeting with all of us, letting them get to know you a little bit.
Great. Yeah, looking forward to doing some more.
Thank you, Will. Thanks, everyone.
Excellent. Have a good night, everybody. See you
Take
next
care.
time.
Good night.
Bye.